as stated on the record earlier, Rebecca Greenlee was a...
You cannot advocate for Ms. Greenlee. Sit down. Everybody today that has a computer and a finger that can type thinks that they're an attorney because they can go on the internet. And if you continue to do that, two things are going to happen. One, the other parties.
So Your Honor, the facts of the case are the facts of the case. And this case is being brought under the Fair Housing Act discrimination. So there have been two tenants that have lived up front. One is age discrimination. The other one is race, age, and sex discrimination that do not pay rent. They have not sought any legal eviction action against them. They have only sought it against us. The whole entire premise for their eviction action is for the filing of this lawsuit. It is proven through Cheryl's Facebook post and a subsequent text message that was sent to my sister 1 month after the filing of this lawsuit, Your Honor, which will be filed by my sister in an affidavit that will be coming this week. Later next week. Your Honor, as far as it being any kind of defense in an eviction action, it is very clear that this is retaliatory discrimination. So by law, there are 4 things that need to be proven for a prima facie showing of retaliatory discrimination. That plaintiffs engaged in a protected act under Chapter 4112 under Chapter 4112 of the Revised Code, Your Honor. That would be filing of this complaint. So ORC 4112.055.
Are you a named party in that complaint?
I'm sorry.
Are you a named party in the eviction?
I am. Yes, they have named eviction as well, Your Honor.
All right. Thank you.
So under 4112.055A, Your Honor, it does authorize us to file a complaint for housing discrimination with the Court of Common Pleas in the jurisdiction in which the alleged violation occurred. So that has been done. We are now protected under that act, Your Honor. So the protected act has been engaged in. That the defendant knew of the protected act. Obviously, they were served with it. They are here arguing against it today. 3, that there was an adverse action. The adverse action, Your Honor, is that the attempt to evict us for nothing more than this lawsuit, which is in the causal connection, Your Honor. So that is why we are seeking injunctive relief to stop them from doing so. At this point, it's going to be hard for them to prove in court anyway because none of them were party to the original lease. So anything that they would have to say in that court would be hearsay, Your Honor. As it has been brought up as well, there were power of attorneys, which now need to be added to this case as well.
When was that action filed?
Yesterday.
Which, Your Honor, if I may, again, after the filing of these motions and obviously after the filing of this complaint.
Yeah, that's evident. All right. Well, the court does not have jurisdiction to interfere and prohibit another court that has jurisdiction over a forcible entry and detainer, which is the municipal court by statute, from proceeding. It is a defense, as Mr. Judkins has pointed out, to that action. But I don't have the authority to enjoin another court from exercising its jurisdiction. And so that claim is denied. And in terms of the other requests for the other parties, Ms. Petro Flugman is not a party to the original action. It's my understanding that, from my reading of the motion, that apparently she runs a business, a beauty shop, and that Miss Rebecca Greenlee rents a booth in that shop and is being attempted to be evicted from that. That would be something that's totally unrelated. I mean, regardless of the motivation, it has nothing to do with this case. Miss Greenlee is not even a party to this case, and it's a totally separate matter. So the court will not join or grant the motion, or deny the motion in its entirety. Ms. Flugman is not a proper party in this case. She may be a witness, but she's not a proper party. Nor is Mr. Judkins as an attorney representing people. He's not subject to being sued for acts that his clients are doing. That's his job to advise them or defend it, and if the appropriate ruling will be made by a court of competent jurisdiction.
she did prepare that herself. She is not here today because she was not ordered to be here today.
Well, no, her hearing is not on her case isn't on the agenda. But I note that her motion asked for to be enjoined in this action as a plaintiff. And so I'm going to deny that motion because she enjoined means to bar, prohibit, stop, or cease some action. And so, therefore, there is no authority under the law to enjoin somebody who's not a party to the action. And so she's not a party in the action, and so she cannot be enjoined from anything. So the motion is denied. All right.
Your Honor, if I may again.
You may what?
Your Honor, as stated on the record earlier, Rebecca Greenlee was a...
You cannot advocate for Ms. Greenlee. Sit down.
I just tried
Sit
to
down.
Your Honor. Okay.
I'm not going to tell you again. You continue to argue on other person's behalf. You may think you're a lawyer. You know, everybody today that has a computer and a finger that can type thinks that they're an attorney because they can go on the internet. Same like you can be a brain surgeon and go on the internet. You know, you're not. You're not an attorney. You cannot practice law, and you cannot advise or advocate for anyone else, and you're not going to be allowed to do that. And if you continue to do that, two things are going to happen. One, I've told you repeatedly not to do it. I've told you repeatedly not to do it. I'm going to hold you in contempt. Two, I'm going to file a complaint with disciplinary counsel of the state to allege that you are engaging in the unauthorized practice of law. And as someone with 50 years experience, I can tell you that what you're trying to do is clearly engaging in the practice of law. You cannot advocate for others. You cannot prepare documents for others. You cannot seek to get relief for others. And that's exactly what you're doing. This is exactly what you're doing. It's clear to everyone. And whether you admit it or not, it is clear. And I don't know what you claim about what you've been allowed to do in Montgomery County, but if judges up there allowed you to do it, shame on them. Shame on them. They were wrong too. Shame. Well, the federal court may be a little bit different in terms of advocating on your own, but I don't know. You're not allowed to practice law without a license in federal court either. All right. Now, that takes care of all the pending motions. And any other pending motions, judges?
No other pending motion, Your Honor. But I would like, just while we're all here for an opportunity.
Okay.
There is outstanding discovery that was.
If you want to discovery, either. What I'm just saying is, if you guys want to agree on something, fine. I'll come back on, and I'll bring the calendar in.